Well, ladies and gentlemen, thank you for inviting me here this evening and attending this lecture. As you can see from the screens, my topic is the marginalisation of parliaments, and let me begin by explaining what that is all about and why I've chosen it as a contribution to this series on whatever happened to democracy. The Australian system of government places a great deal of weight on the institution of Parliament, at least in theory. The role of Parliament is the primary justification for the absence of any form of a Bill of Rights in this country, a feature of our constitutional arrangements which is very distinctive in comparative terms. The intention of Parliament is the traditional touchstone for the interpretation of legislation, which now is the major form of law. And in reviewing the lawfulness of government action, courts assume a chain of authority that runs from government through Parliament to the people, which influences the conclusions that they reach, at least in some degree. The centrality of Parliament in Australian government is not particularly surprising, although some of the conclusions that I have just drawn from it might be. Parliament is, after all, the only directly elected institution. It therefore is the only Australian institution with democratic legitimacy in its own right. It's the foundation of Australia's claim to be a democracy at all. And it provides the critical link between government and the people, from whom the authority to govern in principle derives. If there is a problem with Australian democracy, as the title for this series suggests, and as I also think, Parliament therefore is likely to be part of the story. There are many angles from which this possibility might be explored, including the pernicious contributions of political parties as presently organised to the composition of Parliament and to the control of its proceedings. I have no doubt that this deserves more attention than it's presently likely to receive. My purpose tonight, however, is to focus on what Parliament does, or to be more precise, on what it does not do, because it is excluded from the decision-making process altogether. The range and significance of public decisions in relation to which Parliament has no say has increased steadily over the last, say, 30 years and exponentially over the last decade, contributing to the malaise of democracy, or so I claim. I acknowledge that sometimes, although I think not always, Parliament is complicit in its own marginalisation. This doesn't resolve the problem, however, but is merely another manifestation of it. Parliament is the means to a democratic end. It is not an end in itself. I want to begin tonight by explaining how and why the involvement of Parliament in public decision-making matters, before moving to examine two principal causes for its exclusion. One, the concept of inherent executive power, and secondly, the network of intergovernmental arrangements. I should make it clear that I'm referring to all Australian parliaments, state as well as Commonwealth, although sometimes the argument applies a little differently between them. I will try to bring the lecture down to earth with some contemporary examples, including the highly contemporary question of the policy of placing Christian chaplains in public schools. I will end by suggesting that there may be some signs of hope in both decisions of the High Court and, even more doubtfully, political practice. Such as it is, however, the hope is unlikely to be realised without a concerted push from outside the formal institutions of government, in a further illustration of the extent to which Parliament has lost sight of its own role in the democratic scheme of things. One of the difficulties of evaluating the role of any Parliament in the Westminster tradition is deep-seated disagreement about what it's supposed to do. On one view, the long historical roots of the institution of Parliament make it a body that advises on but ultimately gives consent to proposals emanating from government. And that advise and consent formula can still be found as a description of the role of Parliament in the constitutions of some of the Australian states. In modern times, this essentially passive role for Parliament is powerfully reinforced by the operations of responsible government, pursuant to which governments depend on the support of Parliament for their continuation in office, at least on questions of confidence. On the other hand, the democratic credentials of Parliament, the claims made for parliamentary approval, comparisons with legislatures elsewhere, and perhaps also public expectations, suggest that Parliament should play a more deliberative role in relation to at least two of its primary functions, enacting legislation and scrutinising the actions of executive government. These tensions are as unresolved in Australia as they are elsewhere. They are masked, however, here by our penchant for bicameralism. And this has endowed us with parliaments that are both passive and occasionally deliberative, presenting the tension as one between two parliamentary chambers. This more deliberative role of the less democratic House is a paradox of the Australian system of government. It also provides one of the many incentives for governments accustomed to relying on the acquiescence of the lower house to seek to avoid Parliament altogether. But it's not otherwise necessary to pursue this tension tonight. Whichever of these two views of the role of Parliament you hold, the involvement of Parliament in public decision-making has distinctive advantages that enhance democracy and that cannot otherwise be secured. In particular, parliamentary debates are public debates, and parliamentary proceedings are published in full. Parliament is a forum in which governments are expected to publicly justify proposals for action and in which their justifications can be publicly questioned and challenged. Parliament is representative of a wide range of views, loosely reflecting the Australian community. When parliamentary involvement takes the form of legislation, additional advantages follow. Legislation is carefully and professionally drafted, however much we may complain about it in practice. Legislation is publicly and systematically available. Legislation is unable to be changed without a further public and parliamentary process. And legislation produces a degree of stability, predictability, and accessibility in public policy that is the foundation for the rule of law. Of course, there are grounds for myriad criticisms of both the form of legislation and parliamentary procedures, and there is plenty of room for improvement. But the situation is very much worse when there's no parliamentary process at all. I noted earlier that there are circumstances in which Parliament contributes to its own marginalisation. The most common arises when Parliament delegates its power, legislative power, to the executive branch. I don't propose to dwell on this tonight. Delegation of some legislative power is necessary in any system of government to prevent parliaments being swamped by minutiae, which would marginalise them in another way. And Australian parliaments generally retain a degree of negative control over delegated legislation in any event through procedures for disallowance of delegated legislative instruments. But let me make 2 points in passing, both of which relate to my theme tonight. First, there are signs of delegation creep, of the delegation of lawmaking power that is so significant that it should be retained by Parliament itself. I was reminded of this yesterday by an article in The Age suggesting that new legislation would give the Commonwealth Treasurer a power to adjust or delay adjustments to the rate of superannuation contributions without further reference to Parliament. This proposal may have been overtaken by negotiations over the mining tax later in the day. I haven't had time to check whether that is so. On the face of it, however, those are decisions that are too significant to be delegated by Parliament, and the attempt to do so illustrates a more general trend. My second point in passing is to observe that some legislation approved by Parliament now confers authority on the government in such broad terms that it hardly imposes limits at all. The purpose of this often is to avoid the courts and to avoid the rigours of judicial review. Nevertheless, the practice augments the authority of the government vis-à-vis Parliament as well. Let me give you one extreme example that was thrown up by the never-ending tussle in this country over immigration policy. In one of the critical immigration cases, Counsel for the Commonwealth suggested to the High Court that if the court was not minded to give effect to its the parliamentary clause ousting the jurisdiction of the court, future legislation might be drafted in different ways. It might be drafted instead, said this brave barrister, to give the minister a totally open-ended discretion as to what aliens can and what aliens cannot come to and stay in Australia. The court was not impressed, but the court would have to deal with legislation of that kind if it happened, and I suspect that we will see further examples of this kind in real laws in the years ahead. For the rest of my time tonight, I will focus on the two areas I identified earlier in which government acts without any involvement of Parliament at all, apart from securing any necessary appropriation of funds. I won't digress to explain the appropriation process, for which you should be duly grateful, except to note that the appropriation of monies at a very high level of generality in the context of the budget process gives Parliament effectively no say at all. The first of the two areas on which I want to concentrate involves action taken in the exercise of, in the jargon, inherent executive power, or in other words, the power that is held by governments that can be exercised without reference to their parliaments. The scope of inherent executive power is in large measure a legacy of the evolution of the relations between the Crown and Parliament in Britain from the 17th century on. In Australia, that legacy is overlaid by the written constitutions, which nevertheless, at the very best, refer simply to executive power, assuming that the term is understood. Without enmeshing you in the intricacies of the meaning of the term, let me just say that the actions it covers generally are taken to fall into two categories. The first category comprises actions that historically might have been taken by the monarch as sovereign, including, importantly, the power to enter into international arrangements or treaties, and the power to declare war and peace, and to commit troops to armed conflict. Actions of this kind sometimes are described as prerogative powers. In the Australian context, these particular prerogative powers are held by the Commonwealth as the level of government that represents Australia on the international stage, rather than by the states. The second category of inherent executive powers comprises actions that might be taken by any ordinary person, including, relevantly for present purposes, entry into contracts and spending programs of various kinds. In the hands of government, these actions can be used to shape behaviour in ways that have regulatory effect. Both Commonwealth and state governments have powers in these categories. Both of these types of actions have become significantly more important in modern times. In conditions of globalisation, international arrangements have expanded dramatically in both breadth and depth. Their form and scope has also been affected by international concern about terrorism in the wake of 9/11 and subsequent global events. And in relation to contract and spending, in contemporary conditions of enthusiasm for corporatisation and privatisation, reliance by governments on contracting and spending to achieve their policy goals has also become extremely fashionable, attracting the label of government steering, not rowing. Relevantly, both of these categories of executive action also have features that can be used to shield governments from other forms of democratic accountability as well. Actions in the exercise of so-called prerogative powers are often claimed to require confidentiality in the interests of intergovernmental comity or national security, and there are plenty of examples of that around at the moment. Conversely, actions in the exercise of so-called ordinary person powers, such as spending and contract, may attract claims for confidentiality on the grounds that they are commercial in confidence. To the extent that governments possess these powers, there is considerable incentive to use them, sometimes as an alternative to resort to legislation. Actions can be taken without reference to Parliament, avoiding in particular the need to negotiate with difficult upper houses. Actions in the exercise of pure executive power are more difficult for courts to review for questions of lawfulness. And in the case of the Commonwealth, executive action has the additional potential advantage of avoiding federal limitations on its power as well. In the past, the Commonwealth has taken a rather benign view of the extent to which its executive power to contract and spend is affected by the federal division of power at all. But even if it is so affected, government action based solely on the executive power is more difficult to challenge on federalism grounds, if only because the ambit of what is actually going on is so much less clear. A host of currently controversial questions involve governments acting in the exercise of what they assume is their inherent executive power, avoiding Parliament with all the downsides from the standpoint of democracy. Let me give you, I think, 6 examples. The first, the apparent intention of the Victorian government to sign the contracts for the East-West Link just before the election, effectively locking in an incoming government, but without clear authorisation even from the current Parliament. Secondly, changes that the Commonwealth Attorney-General is reported to have made unilaterally to Commonwealth service agreements with community legal centres, precluding them from using Commonwealth funds for law reform or advocacy. Thirdly, the Commonwealth Government's decision to make a military commitment in northern Iraq in circumstances that left somewhat obscure the international legal basis for Australian involvement, again without debate in Parliament, an issue that is presently being discussed in Parliament itself. Fourthly, the reintroduction of the titles of knights and dames, again by executive fiat, this time in the form of advice to the Queen. Fifth, negotiations that presently are underway for the Trans-Pacific Partnership Agreement with potential adverse implications for a range of Australian interests, from food labelling to patents for medication, again without reference to Parliament, at least so far. Sooner or later, once it's a fait accompli, that agreement will be tabled in the relevant parliamentary committee, but change is highly improbable in that situation. And then finally, last but by no means least, the home insulation program, on which the Royal Commission reported so critically yesterday, was yet another example of an executive spending program that lacked a legislative framework, which seems to have been a large part of the problem. One of the most notorious executive programs is the National Schools Chaplaincy program, which provides a useful case study for our purposes tonight. The scheme implements the policy of successive Commonwealth governments to place religious chaplains in schools. It was initially based purely on an exercise of executive power, without any involvement of the Commonwealth Parliament, other than a substantial appropriation, $207 million over the initial 5-year period, $243 million for the next 4 years. If such a program is to exist at all, and that of course is a controversial question, there is nevertheless a strong argument for providing it with a legislative framework that has been publicly justified and shaped by public debate. A program of this kind needs to be carefully drawn to fit the contours of Australia's diverse society. Legislation also would have been useful to provide clear and defensible definitions of, for example, what's involved in proselytising, what do we mean by pastoral care, and to prescribe minimum qualifications for chaplains. The ground rules for the program instead were shaped by policy guidelines. These were produced within the relevant government department and were and are subject to frequent change. Major changes made in this way have included the critical question of whether secular advisors are available through the program or not. I note for future reference that, even leaving aside the problem presented by the absence of legislation in relation to this program, it was obvious from the outset, at least to some of us, that the school chaplains program might not fall within Commonwealth power at all from the standpoint of the federal division of powers. As so often happens with controversial programs, this one eventually ended up in the High Court at the instance of an aggrieved parent, the now very famous Ron Williams. In a very important decision in 2012, the High Court held that the program was unconstitutional. Significantly for our present purposes, 4 of the 6 judges that constituted the majority reached this conclusion on the basis that a program of this kind needed supporting legislation. The detail of their reasoning varied a little. In essence, however, the court denied that a government exercising public power and spending public money could be equated with an ordinary person to such an extent that it had unlimited power to contract and spend without approval by both houses of the Parliament. In the wake of this first Williams decision, it therefore became clear that at least some contract and spending programs require parliamentary approval in the form of legislation. Which programs fall into this category needs to be clarified over time. On the basis of Williams, however, they are likely to include contracts in areas in which the Commonwealth is in competition with the states or which are novel in some other way. In the kerfuffle that followed, the government identified another 420 pure executive spending programs in addition to the school chaplains program, which now were potentially at risk. In a disappointing, if predictable, reaction, legislation was quickly introduced and equally quickly passed in an attempt to retrospectively validate all 420 programs. This legislation was very odd in several ways. First, in the case of each program, and the legislation doesn't make gripping reading, as you can imagine, in the case of each program, the general description of program outcomes from the executive documents was dumped into what nominally now were regulations created by a statute. In the case of the chaplain scheme, for example, the program was described in extraordinarily general, and I think possibly misleading terms, as, and I quote, to assist school communities to support the well-being of their students, including by strengthening values, providing pastoral care, and enhancing engagement with the broader community. The new legislation also authorised the executive to make regulations to support future spending programs. And while the legislation was initially explained as transitional, to enable the government to sort out a more satisfactory long-term solution, it quickly became apparent that it was here to stay, perpetuating the effective exclusion of Parliament from decision-making in relation to such programs in a different way. The provision of a legislative framework, even in such unsatisfactory form, however, had another consequence. It made it easier to challenge the program on federalism grounds. Back to the High Court went the indefatigable Mr. Williams, and back to the High Court went the Commonwealth in defence. The Commonwealth argued not only that the program was a benefit to students and therefore within the scope of its federal constitutional power, but also that, in any event, contracts of this kind did not require legislation, with the implication that the court was wrong the first time around. The Commonwealth lost in the second Williams decision, handed down earlier this year by a unanimous High Court. For the moment, therefore, the first case stands. Legislation is required for major contract and spending programs, at least in the Commonwealth sphere. It remains to be seen whether and how this doctrine will extend to the states. The legislation, in turn, must be supported by a federal head of power. At least some of the other spending programs remain vulnerable to challenge on one or other of these grounds. Now, there's more to be said about the fate of the school chaplains program in the aftermath of Williams No. 2, but I need first to turn to the second of the two areas I mentioned at the outset, in which the Australian system of government regularly bypasses parliaments. Government in Australia relies, to a much greater extent than most Australians understand, on arrangements between the various Australian governments. Ministers and other public officers meet regularly in a network of intergovernmental councils where they deal with a vast range of matters, including, sometimes, settling the text of legislation. It's no accident that a subset of these councils is classified as legislative and governance fora. Hundreds of intergovernmental agreements regulate government actions in hundreds of programs. The precise number is impossible to determine. Much significant legislation is the result of intergovernmental action. While by definition legislation requires some involvement of Parliament, the most tightly integrated legislative schemes require parliaments effectively to abdicate their powers. Under these complex arrangements, all participating parliaments adopt the so-called template legislation of one of their number for the foreseeable future, leaving amendments to be determined by ministerial agreement. And billions of dollars are transferred from the Commonwealth to the states each year, often on condition as to how the money will be spent by the states in the exercise of their own constitutional powers. These processes are dominated by the executive to such a degree that the Australian system is often described as a system of executive federalism. A closer look at how intergovernmental arrangements work in practice help to illustrate the point. First, intergovernmental councils not only comprise members of the executive, but tend to be treated as an executive plaything, to be refashioned at will despite their practical significance for Australian government. Thus, for example, the Rudd-Gillard governments reconfigured all the ministerial councils and renamed them COAG councils, thereby removing the only formal acknowledgement that council members might be accountable to their own parliaments. Similarly, the incoming Abbott government reconfigured the councils again, dramatically reducing their numbers and altering their constituent arrangements. There was no public debate on any of this, much less a justification of the changes to the respective parliaments or to the public. Secondly, intergovernmental agreements are signed by governments alone. The involvement of Parliament is rare even when, as often happens, the agreement has implications for the form of legislation. Thirdly, cooperative legislation typically is approved by ministers in a council, presenting any parliament involved with a fait accompli. Next, the effective exclusion of parliaments from these processes creates a democratic deficit, with implications also for executive accountability. The principal measure taken to fill this gap was, until recently, the creation of what was called the COAG Reform Council, entirely as an exercise of executive power, comprised of technocrats to measure primarily state government performance. It says something about the state of Australian democracy that a body of this kind was assumed to be an adequate substitute for democratic accountability. it's impossible for an outsider to gauge whether the COAG Reform Council had significant effect. In any event, however, it no longer exists, having been abolished in this year's budget. The ease with which executive power could be used to create the council was matched only by the ease with which it could be dismantled. And finally, most fiscal transfers are dominated by the executive as well. Conditions typically are attached to funds by the government and accepted by the government of the state concerned, again without reference to either parliament. At this point, intergovernmental arrangements link again with the school chaplain scheme. You'll recall how the immediate outcome of the second Williams case was to establish that the school chaplain scheme, as administered by the Commonwealth, was invalid. The Commonwealth government then announced that the program nevertheless would continue now as a grant through the states. But states are not constitutionally obliged to accept such grants on the conditions imposed by the Commonwealth. And at least some state governments had already made it clear that they were opposed to purely religious chaplains on policy grounds, which presumably took some account of the conditions of their state communities. On the latest media reports, nevertheless, the plan is forging ahead. The Commonwealth appears already to have attached conditions to the grant, exercising its authority to do so by, quotes, written agreement under the open-ended legislation enacted by the Parliament following the first Williams case. State governments will accept or, in a few cases, reject the grant by signing, or alternatively not signing, the agreement. In neither case will a state parliament be involved. It's unlikely that the agreement will be a public document. There will be no public debate on the merits of the program in any state, no public consideration of whether the grant should be accepted on these conditions, no opportunity to influence its form, and no democratic accountability for its implementation. In many ways, the marginalisation of Parliament is a sad news story. Executive power is on the rise across the board. Of course, executive power can be used for beneficial purposes. Of course, it has attributes of flexibility, speed, and discretion that make it a useful tool for many things. But reliance on executive power comes at democratic cost in terms of openness, participation, stability, and ultimately, I would claim, effective government. Democracy requires a line to be drawn between decisions made by the executive alone and decisions that involve the Parliament. There are signs that in Australia, the line is in the wrong place for contemporary times. Worse, there are signs that Australian decision makers have lost sight of the principles that should determine where and why the line is drawn, or that those who understand what is at stake lack the fortitude to demand that the principles be observed. One consequence of this trajectory is the decline of Parliament as an institution. This is not the only reason that we might wonder where democracy has gone, but it is a contributing factor. As I suggested at the outset, there is a little hope around. Most obviously, the decisions of the High Court in the Williams cases have begun to redraw the boundaries of executive power in a way that highlights at least some of the values in play. These cases could and should be a catalyst for change. Even leaving democratic considerations aside, any government seriously interested in budget reform also should seize this opportunity. Less obviously, the government's proposal for federalism reform hold out hope for other forms of change. While it is early days yet, if the federalism white paper proceeds, and if it is implemented, it could ameliorate several of the problems that I have canvassed tonight. It should, for example, limit the range of matters for which deep intergovernmental cooperation is sought. It should also provide greater transparency for those intergovernmental arrangements that continue, including through restoring a role for the parliaments of the participating jurisdictions. It could reduce the fiscal imbalance between the levels of government and therefore state reliance on conditional grants, and equally Commonwealth interest in undisciplined pure spending programs. And it might even restore state politics as a worthwhile place to be, encouraging the refashioning of state parliaments as contemporary democratic institutions. Indeed, it has to do that if it is to work at all. At least for the moment, however, hope needs to be tempered by reality on both fronts. Any of these changes involve major adjustments to present practice. Any of them will require vision and a measure of self-sacrifice on the part of the principal decision makers. The skeptic in me tells me that none of them is likely to occur solely from the inside out. Ideally, there needs to be a push from the wider community, but that will be hard to achieve in a society that is not used to reflecting on the principles that underpin its system of government, particularly when the principles are abstract, complex, and unfamiliar. In the interest of starting somewhere, I was very pleased to accept Ray's extremely kind invitation to deliver this lecture tonight. And I'm grateful to you for listening to me so patiently, and I'm very happy to answer any questions you may have, or for that matter, to listen to any views that you have on these important questions. Thank you.